Sir, can you hear me?
Alexander on behalf of the people.
This case opens quietly, but don't let that fool you. What you're about to witness is a slow-motion collapse of credibility inside a courtroom. This is Levante Shannon standing before Judge Simpson facing an OWI third offense with a blood alcohol content of 188. That's not a technical slip. That's a serious charge. And what makes this hearing explosive isn't just the offense. It's what happens after the court tried to give him a chance. Shannon is already under supervision. He's being tested. He knows alcohol is forbidden. Yet the system starts lighting up. Positive results, missed retests, suspicious patterns. And now, we're here on a bond violation. The defense asks for grace. The prosecution raises red flags. And Shannon, he walks in with a story that's about to be tested under pressure. This isn't a trial about drunk driving. It's about honesty, about whether the court can trust what a defendant says when the data says something else. You'll see Judge Simpson do what experienced judges do best: track patterns, compare numbers, and cut through excuses. You'll hear Shannon claim he didn't know non-alcoholic beer still had alcohol. You'll watch his story evolve in real time, and you'll feel the tension rise as the judge begins to suspect something worse than a mistake.
Can you hear me? Can everybody hear me?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Shannon. Mr. Shannon, will you state your name for the record?
Levante Shannon, Levante Cedric Shannon.
Okay. What are we doing today?
Your Honor, today's date and time, we are asking for an adjournment. Mr. Shannon has completed an inpatient treatment recently, so I'm asking for documentation from him so that we can further discuss negotiation with the prosecutor's office.
And Your Honor, before we start today, I did want to make the court aware that he's had multiple missed tests as well as positive tests from August 12th until September 10th, which is very concerning to the people given that this is an OWI third in which the BAC was 0.188 and he's had numerous previous OWIs.
This is where the stakes crystallize. The prosecutor doesn't raise her voice. She doesn't dramatize. She just lays out the reality. This is an OI third offense with a 188 BAC. That's more than twice the legal limit. And now, we're seeing positive alcohol readings after arraignment. That detail matters. Courts expect defendants to tighten up once they're formally charged. The moment you're arraigned, you are on notice. Every test from that point forward is a measure of whether you're taking the court seriously. Notice how she frames it. Multiple ETG tests, positive from August through September. This isn't a single blip, it's a pattern. In bond hearings, patterns are everything. Judges don't need proof beyond a reasonable doubt. They need to assess risk to the public, risk of noncompliance, risk of dishonesty. And then comes Shannon's explanation: non-alcoholic beer. I was just drinking for the taste. On its surface, it sounds almost reasonable. Many people genuinely believe non-alcoholic means zero. But here's the problem. Courts don't operate on vibes. They operate on data. ETG tests detect alcohol metabolites. They don't guess. They measure. And the numbers being cited, 0.027, 0.021, 0.020, aren't trace contamination. They suggest ingestion.
And also, just so that you know, he's probably going to repeat what he put in the chat, which he probably shouldn't have put in the chat.
I saw that, Your Honor.
Yeah.
Can I say one thing?
I saw the distress on your face.
Yeah.
Mr. Shannon?
I had no idea because the scrambler, it was non-alcoholic beer. That's what it said, non-alcoholic. So I'm on naltrexone. I can't, this right here is a blocker. You can't get drunk on it. So I was just drinking for the taste of beer. I was, we were barbecuing and things like of that nature. And I was just only drinking for the taste of beer.
Your Honor, if I
you might want to jump in here, Miss Apple.
Yes, Your Honor. So the information that Mr. Shannon did put in the chat, Your Honor, I would ask for some consideration considering this confusion on it. Mr. Shannon.
Confusion on what?
I didn't know that non-alcoholic beer contained alcohol because I was on the scrambler and it never came up.
Mr. Shannon.
Huh?
Yeah, it would be concerning as he did test, when he did test positive, he was at a 0.027, 0.021, 0.020, 0.016, and so on.
If the court would allow Mr. Shannon one final opportunity. He would report for a
To
scram
do what,
tether
Gray?
No,
to
I'm
not to
done.
prove to the court
I
that
threw it
he
all out.
is. Your Honor, I request on behalf of my client one final opportunity now that it is very clear that he is not to consume even non-alcoholic beer, as there may be alcohol in it, and be placed on a scram tether. And that I can get the documentation regarding the treatment program. He did inform me that he completed a 30-day in treatment at Brighton Recovery Center and provide that to the court and to the prosecution.
Oh, I need a copy of the report because I don't have the report from community correction. This is one of those times that maybe if the client hadn't started talking.
That single line from Judge Simpson tells you everything about how this hearing is tilting. One of those times, maybe the client hadn't started talking. That's judicial shorthand for the defendant is hurting himself. In court, silence can be protection. Over-explaining is often a red flag. Judges hear hundreds of excuses. They develop an ear for stories that expand under pressure. Watch how the dynamic shifts here. The defense is trying to slow things down, asking for documentation, asking for time, framing this as confusion. But the judge isn't focused on sympathy. He's focused on continuity. He wants reports. He wants timelines. He wants to understand whether this is the first violation or simply the first one formally documented. This is where courtroom math replaces courtroom emotion. Judges don't just listen, they reconstruct behavior. They look at spikes, drops, missed tests, retests, time gaps. Each number becomes a breadcrumb. When Judge Simpson starts walking through dates and BAC readings, he's building a narrative that either supports mistake or proves deception. And notice something subtle. The judge isn't angry yet. He's methodical. He's giving space. That's often the most dangerous phase for a defendant. Because once a judge reaches clarity, patience ends. This pause, this recalculation, is the calm before the credibility storm.
You get your wish, Miss Apple, but I don't think so. So what I'm going to do is I'm going to pass the matter. Can prosecutor or the public defender send to Miss Weidling a copy of his report, and then I'll call his case back up. We'll deal with this bond issue in the adjournment.
Understood.
For the past things. Oh, it's right there. Okay. Court recalls the case, People versus Levante Shannon.
Allie Zund on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Shannon. Mr. Shannon, will you state your name again for the record?
You're muted,
You're muted.
Mr. Shannon.
Are you able to unmute your device, Mr. Shannon? You're still muted.
Am I unmuted?
There you are. Please state your name.
Levante Cedric Shannon.
I'm looking at this bond violation report, and my concern is I don't have a report before this one, I don't think. It's arraigned on 8/8. Yeah, because he was arraigned on 8/8. This is really the first violation report. And from August through now, well, because he didn't appear on August 17th. Well, we didn't get the report, but here's my problem with what I'm seeing here. On August 12th, after his arraignment, he gets to an 026, then misses his scheduled retest on that August 12th day. We go 2 days later. Well, on August 14th, he blows a 0.066. Then it slowly goes down, so he then blows a 6.7, a 3.7, 0.37. And that's on the 14th. Then don't really have any incidents, although he's well, no, we do. Then on the 14th, he finally got down to an 04, but that actually went up on that day. Then that's on the 14th. Then we come down to September 8th, and he's missing other tests, but his makeup tests are showing negative. But then we get to September 8th, when he blows an 021, an 020, and a 0.16. Then on the 10th, he blows an 041, and then subsequent tests for alcohol thereafter showing that. And then later on the 10th, he missed a scheduled retest, but then later on the 10th, he's blowing numbers. Now, am I to understand that all of that is from Bud Zero?
This is the moment where the courtroom stops being procedural and becomes personal. Judge Simpson isn't asking out of curiosity. He's testing the story. He has already walked through the data, spikes, drops, missed tests, retests, time gaps. He knows what normal metabolization looks like. He knows what drinking patterns look like. And now he's asking Shannon to commit to a single explanation. All of that is from Bud Zero? That question carries weight, because once Shannon says yes, he's locking himself into a narrative that must survive physics, biology, and common sense. And Judge Simpson warns him explicitly, "I've been doing this a long time." That's not intimidation. That's disclosure. It means, I have heard every version of this story before. Shannon keeps talking. He explains. He adds details. He references scram tethers. He references sensitivity. He references technology. But what he's really doing is drifting, moving from confusion into defense mode. And in court, defensive explanations often feel like rehearsed rationalizations.
Is that the defendant? Hold it. Oh, whoa. And Mr. Shannon, let me just tell you, been doing this a long time. So you might want to think before you start answering me.
Okay.
Am I to understand that all of that's from Bud Zero?
Some of it's from O'Doul's, Bud Zero. I drink Heineken Zero, but I'm on naltrexone. So even if I was drinking alcoholic beverages, it wouldn't, you know what I mean? So it would defeat the purpose. I was just drinking because I'm around people that drink.
I didn't ask you all that.
Yeah. Well, yes, it is.
And you're saying it's from O'Doul's, Bud Zero, and what else?
And what? O'Doul's, sometimes it's Heineken Zeros. I drink a ton of them. And I didn't know because when I was on the scrambler, it never appeared. It never showed dirty. It never showed dirty. It only shows dirty on this machine. This machine is super sensitive. I didn't know it. I didn't understand the technology.
Mr. Shannon,
Yes, sir. Yes, sir, Your Honor.
you blew an 06, a 0.06.
Yeah, and I looked it up on the website after I talked to my attorney, Miss Apple. I looked it up.
Okay, so Mr. Shannon,
Yeah.
I'm going to stop you right now because you already may have talked yourself into jail.
This is the line that freezes a courtroom. You already may have talked yourself into jail. Judges don't say that lightly. This isn't punishment. It's warning. Judge Simpson is telling Shannon that his words are becoming liabilities, that his credibility is bleeding out in real time. Notice what the judge does next. He doesn't explode. He adjourns. He gives counsel time. That's restraint. It's also fairness. Judges often provide off-ramps before consequences, but the message is unmistakable. Get your story straight, or the system will decide for you. The judge even says it plainly, "I hate more than mistakes when people lie to me." That's courtroom DNA. Courts are built on trust. Probation, bond, conditional release, all of it functions only if defendants tell the truth. When that collapses, the court stops experimenting with leniency. What's happening here is reputational damage, not legal guilt, not sentencing, reputation. Once a judge begins to doubt a defendant's candor, every future interaction is filtered through that doubt. Every request becomes suspect. Every explanation is discounted.
But you're not helping yourself
Okay.
at all.
Okay.
But I'm going to give you an opportunity at least to speak with your client. I'm going to adjourn this matter to our 3 o'clock block with the bond hearings. I might suggest to you that between now and then that you get whatever affairs you need to get in order.
Okay.
The first thing you probably ought to get in order, and you can have that conversation with Ms. Apple, is you might want to get your story in order to me. I don't, I realize people mess up. I get
Yes,
it.
sir.
But the thing I hate more than that is when people lie to me.
I understand that.
I'm just going to leave it right there. We'll see you at 3 o'clock.
Yes, sir.
Thank you.
Your Honor, to clarify, is that in person at 3 o'clock or is that via Zoom?
Hang on a second. We had a kid, but we'd like him in person.
Understood. Thank you.
Thank you.
I gotta find the bus schedule. I'm a
All
Mr.
right.
Apple, I gotta find a way to get there. I don't
Right
have a way.
past here. Well, we can provide transportation if you have trouble. I don't think you want us to do that.
Huh?
Nothing.
Mr.
All
Shannon,
right.
you are
Thank
off.
you. We'll
Thank you.
see. That's it for that block. Okay, court stands in recess. We'll be back at the top of the hour or the left.
Do first, you want to do the add-on or you want to do the leave the draw?
Let's do the court does call the case of the people of the state of Michigan versus Shannon, Levante Shannon.
Allie Zend on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Shannon. Mr. Shannon, can you state your name for the record?
Labotny Shannon. Can you hear me?
Yes, I can hear you.
Okay.
All right, this was originally set and I had indicated that Mr. Shannon needed to come in person, but I think there may have been some transportation issues, which he won't have until 4:30, at least we are informed. So I've allowed him to appear for the purposes of this hearing via Zoom.
Okay.
All right. So go ahead. I'm sorry, Miss Apple.
No, Your Honor, I didn't apologize for interrupting, but I want to thank the court for allowing that. Mr. Shannon is currently in Detroit, so he informed me that he would not have transportation until 4:30 today. So I do appreciate the court's courtesy in that. I did have an opportunity to speak to Mr. Shannon after the previous court hearing and was able to get some additional information from him. He would admit today to the violation. He informed me that he was consuming 20 to 30 beers a day of the O'Douls, which contain 0.5% ABV. And so he would admit to consuming that alcohol and understands that that is a violation of his bond, which resulted in multiple positive tests at this time.
This is a strategic surrender. The defense changes course. No more confusion narrative. No more "I didn't know." Now it's admission. But notice how extreme the explanation becomes. 20 to 30 non-alcoholic beers per day. That number isn't persuasive, it's suspicious. It feels engineered to bridge the gap between non-alcoholic and the BAC readings. But Judge Simpson doesn't accept the math. And he explains why. Alcohol metabolizes at a predictable rate. To hit those levels, Shannon would have needed to consume enormous volumes in compressed time windows. The body simply doesn't work the way the defense suggests. This is where science meets storytelling. Courts respect biology. They respect math. They respect patterns. When explanations violate those systems, judges stop negotiating with them. Yet, the judge still accepts the violation. That's important. He doesn't argue forever. He moves forward. That shows balance. He's not punishing disbelief. He's resolving responsibility.
Okay, I get that. Let me just say this, because it is about a 10 to 12 can ratio of the non-alcoholic to the alcoholic beer. Problem with that whole analysis is, while he may have been consuming that amount, and I'm not going to go into great detail on this, because of the elimination rate of a human being, for him to get to that level, he would have had to consume those 10 to 12 in the time it would have taken to do one beer. Yeah, I don't think that happened. That's a lot. But I'll accept the admission to the violation. While I still don't believe what he's indicating in terms of how that happened, but I'll accept the admission to the violation. Did we set a new date on this yet? No. What I will do is well, Ms. Apple, what were the parties intending on doing with this case?
Your Honor, I was seeking an adjournment to get some documentation of treatment that Mr. Shannon completed in discussion of potential resolution or waiving this matter to circuit court.
All right. Well, Mr. Shannon, anything you want to do before I sentence you on the violation?
No, sir. Just that if I give sentenced to some time, I would turn myself in Monday or Sunday night to the county jail.
Well, I'm going to order that the defendant, before I sentence him on the violation, the defendant, you're to surrender to the Washtenaw County Jail by 6 p.m. this evening.
This is where consequence replaces conversation. The judge sets a firm surrender deadline. Not tomorrow, not Sunday, today, 6 p.m. That tells you how thin the margin has become. Shannon asks for flexibility. Sunday night? That question lands poorly, not because flexibility is wrong, but because it arrives after credibility damage. Judges give leeway when they trust. They lock timelines when they don't. Judge Simpson explains it again. He can work with mistakes. He cannot work with dishonesty. That distinction governs everything. Courts are built to manage human failure. They are not built to negotiate with fabrication. Watch the phrasing. You're shading the truth. That's judicial language for selective honesty, not total lies, partial ones. The kind that shift depending on pressure, and once that label attaches, discretion shrinks. This isn't about beer anymore. It's about reliability. Can the court rely on this person to follow orders without rewriting reality? The answer, in this moment, is no.
Or a bench warrant will issue for your arrest with no bond.
Okay. Would it be okay with you if I did it Sunday night though? Because I just got one
No,
thing
sir.
I need-
No, Mr. Shannon,
got
I don't have
one
a problem giving people some leeway.
And that's what I'm
but-
asking for. I got something really important I gotta do tomorrow. And I
Mr.
can
Shannon,
tell
I'm going to advise you to let the judge finish his direction.
I don't mind, and I'll just say this, Mr. Shannon. I told you that I get people that they slip up. I get that things happen. And I'll be able to deal with people when that does. But what I don't like is when something happens and people are lying to me. I think you were lying to me when you were first here. I
Yeah.
think that then through your counsel, but I mean, I understand she's advocating for you.
Mhm.
I don't think you're telling the whole truth in terms of your consumption of alcohol. You could not put 20 to 30 beers in the time it takes for one beer to get into your system because your body can't hold it. And then you're going to be eliminating that alcohol that you're putting in. It doesn't make any sense.
Mr. Simpson.
You can shake your head all you want. You're
No, I
lying
can't.
to me.
This is the emotional apex. Judges rarely accuse defendants directly. When they do, it's because the internal conclusion has already formed. The judge has run the numbers. He has weighed the story. He has heard the revisions. And now he's naming the problem. You're lying to me. Not, I don't believe you. Not, this seems unlikely. Lying. That word ends negotiation. It converts discretion into directive. From this point forward, the court is no longer persuadable. It is managerial. Orders replace discussion. Deadlines replace dialogue. This is a lesson in courtroom physics. Credibility is gravity. Once it collapses, everything falls faster. Shannon shakes his head. The judge doesn't engage. He finalizes. 6 p.m. today. Or warrant. No bond. Every defendant watching this should understand something. You don't lose freedom because you slip. You lose it because the court stops trusting your version of reality. And trust is always easier to lose than to rebuild.
You're shading the truth. 6
Okay,
p.m. today. Do you understand me? I'm done talking to you. Or a bench warrant will issue without bond. Miss Apple, would you like me to then set this for next week or 2 weeks out?
Your Honor, if it could be set for next week, please. Thank you.
Next week, I'll set probable cause conference September 21st, 2023, 9 a.m. Thank you.
Thank you, Your Honor.
This case ends not with handcuffs, but with a deadline that carries the weight of handcuffs behind it. Levante Shannon is ordered to surrender, not because he drank, not because he failed once, but because the court concluded that the story kept changing while the data stayed the same. Judge Simpson's ruling reflects how courts actually operate. They don't just punish conduct, they evaluate character under pressure. They track whether explanations evolve to meet facts, or whether facts get bent to serve explanations. In this hearing, the numbers never moved. Only the story did. The judge accepted the violation. He rejected the narrative. And in doing so, he made a broader point. Compliance is measurable, but honesty is visible. Once a court believes a defendant is reshaping reality, leniency disappears. This isn't about beer. It's about whether the court can rely on what it's being told. And here, the answer became no. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.